Good afternoon and welcome. I'm Elizabeth Slattery, Vice President of Practice Groups at the Federalist Society. Thanks for joining this conversation about Suncor Energy versus Commissioners of Boulder County, which the Supreme Court recently agreed to take up. As always, our usual disclaimer applies. The Federalist Society does not take positions, and all views expressed in this session belong to our speakers. Toward the end of the webinar, we'll open it up to the audience, so please think about questions for our panelists. Questions can be submitted with the Q&A function on the bottom of your screen in Zoom. I'm pleased to now introduce our moderator. Annie Donaldson-Talley is a partner at Luther Strange & Associates, LLC. She previously served in the White House as Deputy Assistant to the President, Deputy Counsel to the President, and Chief of Staff to the Office of the White House Counsel. Prior to her government service, she counseled high-profile individuals and clients in the for-profit, nonprofit, political, and government sectors, while an associate at Jones Day and Patton Boggs in Washington, D.C. Annie holds a BA from the University of Alabama and a JD from Harvard Law School. Annie, please take it away.
Thanks, Elizabeth. And thank you for joining us today for a discussion of a very interesting case granted for argument next term at the court, Suncor Energy versus Boulder County. This case revolves around Boulder County's tort claims against a handful of energy producing companies for producing and selling fossil fuels, both in Colorado and around the world, which the county asserts resulted in a host of harms, ongoing harms, and costs associated with global climate change. This case is one of many similar cases brought by cities, counties, and states across the country based in nuisance and other state consumer protection and deceptive practices laws. The main thrust of all of them is that the fossil fuel-based energy companies have caused global warming that harms communities and have sold lots and lots of oil and fossil fuels over the years, so must pay really huge fines and abatement costs, engage in ongoing mitigation of the harms they're causing, and perhaps do some other things along the way. The court declined to hear a similar case last term in Honolulu versus Sunoco, but granted this case off an interlocutory decision from the Colorado Supreme Court that held that federal law did not preempt the claims in the lawsuit. The questions presented are two issues. First, whether federal law precludes state law claims seeking relief for injuries allegedly caused by the effects of interstate and international greenhouse gas emissions on the global climate. And two, whether this court, meaning the Supreme Court, has statutory and Article 2 jurisdiction to hear the case. With that in mind, I'd like to welcome our panelists today. First, we have Professor Jonathan Adler, the Tazewell Taylor Professor of Law, and the William H. Cabell, sorry if I'm mispronouncing that, Mr. Cabell, Research Professor at William & Mary. He's also the author of many books, including, maybe most relevantly to our conversation, Climate Liberalism, Perspectives on Liberty, Property, and Pollution. We also have Michael Williams, the Solicitor General of West Virginia, one of the leading red states on environmental litigation in the country. Among other things, Michael was one of the brains behind the landmark West Virginia versus EPA case back in 2022. O.H. Skinner is the head of Alliance for Consumers, an organization dedicated to fighting for consumers and legal reforms. Prior to that, he was Solicitor General for Arizona, back then, a wonderful red state fighting some of the great fights of our time, and led numerous successful cases, both about the rule of law, but also in securing important consumer protection wins. Gentlemen, let me thank you for being here again today, and let me kick off with an opportunity for you guys to give us the bottom line up front. We all know what the headlines say and how this case is portrayed in the media. Big oil versus climate change. This is the big climate change case. But I actually think there's a whole lot more going on here and many, many more layers. So let me turn it over to you as experts and start with a big question for you, which is, how did we get here and what's at stake? Professor, I'm going to let you take the lead in this, and then we'll all follow from there.
Sure. Okay. So, in terms of how we got here, over the last 20 years or so, there have been various efforts to use litigation to spur action on climate change in the absence of any legislative action at Congress of any meaningful sort. This has taken a bunch of different forms. One form certainly was the litigation against the Environmental Protection Agency, which led to Massachusetts versus EPA. which is the basis for the Environmental Protection Agency's assertion of authority over greenhouse gases as pollutants under the Clean Air Act. There was initially an attempt to file some federal common law nuisance claims against large emitters seeking injunctive relief to constrain their emissions. Those cases basically went away, as I think most observers expected they would, because once the Supreme Court concluded that the EPA had jurisdiction over greenhouse gases under the Clean Air Act, then a federal common law cause of action, particularly for injunctive relief, was no longer viable. But in the wake of those cases, various state and local governments have filed various state law claims against producers, emitters, others involved with fossil fuels, largely seeking damages for the costs that they claim that they are bearing as a consequence of that portion of climate change, which is driven by anthropogenic emissions of greenhouse gases. This case is Boulder County, Colorado, claiming effects on things like infrastructure and the like caused by climatic and other changes that affect them. Similar cases have been filed around the country. This litigation has been going on for a while. These cases have almost exclusively been filed in state courts, again, under state law. There was one exception that was filed in federal court. And initially, there was a round of litigation trying to have these cases removed to federal court on various theories that would justify removal, including complete preemption. Those removal efforts failed universally. Every Federal Circuit Court of Appeals to have considered that claim rejected it, largely on the grounds that complete preemption was not something that could be established here. Now we're kind of on the second round as some of these state court proceedings have, some of these cases have proceeded in state court. There have been efforts to have them dismissed either under state law, on state law grounds, or out of preemption or other sorts of concerns. In some states, those cases, the cases have continued. In others, the cases have been dismissed. Hawaii was notably one where the case was not dismissed, and that is going to proceed in state courts there. And then this case in Colorado courts, the district court refused to dismiss on a variety of claims, preemption, jurisdiction, a range of other claims that the defendants made. The Colorado Supreme Court considered the preemption argument for dismissal and rejected it. And so a petition for certiorari was filed asking the Supreme Court to review whether or not these claims are preempted by federal law. And that should really be understood to contain two different types of arguments. One is an argument that these claims are preempted by the Clean Air Act, by law that Congress has enacted. And then there are a second set of claims, which are basically that this sort of claim is preempted by the constitutional structure or broader federalism concerns. The Supreme Court granted cert in this case and added to the case some set of questions presented that had been suggested by the respondents, which really go to whether the court has the jurisdiction to hear this case in this posture, in particular, whether or not the court has jurisdiction to hear what some might characterize as an interlocutory appeal of ongoing state litigation, and whether or not there's Article 3 jurisdiction to hear that. And certainly that suggests that the court is interested in this, not only the substance of this case, whether or not federal law should be understood to preempt these sorts of claims, but also when it is or is not appropriate for the Supreme Court to intervene in ongoing tort litigation in state court, which is certainly something we've seen the court express or demonstrate some reservations about in recent years. So that's kind of how we got there, and I'll let my co-panelists say what they think is at stake, and then I'm sure we'll have a lively discussion on that.
Rach, do you want to talk about the wider implications of this case, both for when the court is going to hear these cases and what you think is at stake, both in this case and maybe in this genre of cases?
Yeah, of course. So from a consumer perspective, the biggest thing that's happening here is just the idea that it's a public nuisance case that is kind of set aside the climate change aspects of this and the parts that'll be in all the headlines and that the professor will talk about and Michael will talk about. Fundamentally, public nuisance is a very scary tool from a consumer's perspective because the end result of a public nuisance case isn't really damages. I mean, I know the professor said it's damages, but like fundamentally what you're supposed to do is get the nuisance abated. So if it's a log on a road or if it's a factory that's spitting out chili smells, which is a thing from Los Angeles, you would get a court order saying like put a scrubber on your smokestack or lift the log out of the road, right? But here, what they're fundamentally asking for is billions of dollars under the guise of the only way to avoid the effects of climate change is to abate the nuisance of climate change is to rebuild all of our buildings and put money into a green new deal fund that goes to nonprofits and to fund a giant network of NGOs. These kinds of claims are also brought about things that have nothing to do with climate change, right? So you've seen them against cars, you've seen them against guns, and fundamentally there, the same abate the nuisance thing starts to beg the question of whether you're going to get a court order that basically removes products, bans certain things, and tries to reshape the American economy from one courtroom. And so when I think about this case, what's interesting to me is that nuisance is at the heart of it. And the other thing that is very interesting is that it starts to ask, the professor flagged this like structural constitutional. I think the missing thing in all the other headlines about this case, and the missing thing that is, a lot of ink is spilled in the briefs, and I'm sure there's a lot of very good argumentation on both sides about the Clean Air Act, but fundamentally nuisance cases, when the identified nuisance is international or global climate change or nationwide gun violence or anything else of that scope, immediately implicates whether one court can mandate activity and change the ability of people to operate in other states. How far can that go? What are the limits on that? I think this is a discussion point that is going to be present in a lot of FedSoc discussions in the next 3 years. You see a lot of efforts by California and other states to directly regulate outside their boundaries. Michael's involved in litigation now about greenhouse gas disclosure rules that are supposed to be governing conduct outside of certain states' boundaries. But fundamentally, these cases, this case at the Supreme Court out of Boulder is just that case in litigation form. The end result of a win for Boulder is going to be injunctive relief and other changes that would require the defendants to change their behavior all across the country and potentially all across the globe. And so you're starting to press on some of these same questions. We've seen the court talking a lot about nationwide injunctions. Well, those same concerns fall into place when you're talking about one court in one state using one state's common laws to affect and regulate action outside of that state, right? You start to see questions of how far can a state's jurisdiction reach, right? We have a lot of aspects of the Constitution, whether it's the compact clause, whether it's the guarantee clause, whether it's the export-import clause, that speak a lot to when states can regulate outside their boundaries or delegate authority between themselves, or how they can work together. All of those start to get implicated when you have a case asking for a nationwide change on a massive policy scale, right? Some of the same things that are coming out in our discussion of major questions doctrine and non-delegation, they're present here too, right? Historically, public nuisance was a tort that would be to solve a local problem, right? The factory that I just identified, the log on the road. In Phoenix, Arizona, where I live, we've had a situation where somebody brought a claim against the city to scrape a homeless encampment, right? These are all very localized land-based problems. But now you have a question of, is public nuisance going to be an allowable thing that allows one court to start to speak to the entire nation's economy, to the entire nation's relationship with each other, and whether one state's going to get to have guns or not, or cars of a certain type, or energy of a certain type. And that starts to implicate some of the same, like, how is the court going to view that? And I think that that's really going to be what drives a lot of this case, if I'm being honest. I think it's the underlying reason why these cases are actually interesting and not just an interesting, administrative law and preemption fact pattern for a law school exam. And so I think that's the stuff that to me is deeply interesting, and it goes far beyond climate change, and it goes far beyond the Clean Air Act.
Yeah, I hear that you've identified a number of ways that this case is representing a number of different things that have been building for years and years in the law. And I think the best way to go forward from here is to go ahead and start unpacking those. So I think the most obvious thing that's in front of the court is this idea of who gets to decide these big cases, these big issues, these big national issues. And Michael, if you want to go ahead and give us a little bit of background about how you see this. For reference, the Michael State, West Virginia was part of a multi-state brief advocating for cert to be granted in this case, and talked about a lot of the issues that OH has just identified. So Michael, I'll turn it over to you for a few minutes to talk about that.
Yeah, thanks, Annie. And I think that fundamental question really explains why we're taking the position that we are in this case. I think sometimes when people hear that a state comes in and is pushing for a more fulsome conception of preemption, they think there's a tension in that, because often maybe the instinct is to fight the notion of preemption as a state. But I think the ultimate reality of this case is that it doesn't serve the state's interest to ignore the preemptive effects of both federal common law and the Clean Air Act ultimately, in addition to some of those structural constitutional issues that OH was talking about. So that's why a state really ends up in a position like this one, where we end up on the side of saying the federal government should have a bit more power. As far as I'm concerned, this case in these sorts of cases are an extension of the work that we did in West Virginia v. EPA, where they are ultimately about who the proper decision maker is. And I think that our philosophy has always been that a deliberative process that involving all the relevant stakeholders and with the closest nexus to those actual stakeholders really is the best result for everyone involved. And I think, unfortunately, I think the court has sort of level set when it comes to the administrative side of the equation, and they've recognized that that's not going to provide us the deliberative process that we want. But now we're headed back into state courts where a single judge or a single county circuit court or the like can really impose a degree of crushing liability that acts as de facto litigation. But maybe worse than even in the EPA circumstance, you have de facto regulation by a less accountable decision maker, but then you also have this balkanization effect, of course, where you're going to get inconsistent results across a variety of jurisdictions that impose competing obligations, and in some ways, or not in some ways, in every way, punish conduct that it's actually lawful where it occurs. And so we see a real tension and a real inconsistency in placing the point of decision there. And I think Suncor actually isn't the first case where I think the court has recognized that recently. I think some of the removal cases that you've seen this term, like Enbridge and Plaquemines, those are energy cases as well. And I think there's an increasing recognition by the court that there's going to be a real problem if we continue to allow individual state trial courts or state decision makers to be making these decisions of serious national import. So ultimately, that's all we're asking the court to recognize through amicus efforts and similar litigation, is that Congress has made a deliberate judgment here to place those decisions in the hands of Congress, not in the hands of individual states. And I think we see that in the Clean Air Act, and this is maybe where we'll begin to take some issue with one another, but I think the Clean Air Act really is an express acknowledgement of the fact that Congress and a federal decision maker is really supposed to be making the decisions when it comes to interstate pollution. West Virginia has been very aggressive when it comes to preserving our right to regulate and dictate pollution management when it comes to the activities within our own borders. But I think there has to be a practical acknowledgement that's expressed in the Clean Air Act that when it comes to interstate pollution, implicating international issues or national level issues, that's not a decision that can be made on a state by state, local level basis. And I think the reality is too that Congress is merely adopting or acknowledging a principle that's existed as a matter of federal common law for decades now. So in some ways, it's just an extension of that same philosophy and that same practical recognition that the nexus of decision making can't be happening in this balkanized, inconsistent way. So that's how West Virginia and states like us, obviously Alabama has been another incredible leader in this space. That's why I think we're recognizing the reality that preemption really has some force and some power in a context like this one, a uniquely national interest.
Mr. Adler, I'm going to give the floor to you because I understand that you have a very different view than that.
Yeah, I do. I think most of what we hear in these discussions are a lot of policy arguments about why litigation of this sort perhaps would be a bad idea and why perhaps Congress should seek to preempt it or provide protections the way Congress did when public nuisance litigation was used against gun manufacturers. There was a case just this past term at the Supreme Court where the court applied one of those statutes. But when we look at the federal laws that we have in place, when we look at the way the Supreme Court has interpreted those laws, when we look at the history of nuisance litigation going back to the nation's founding, including in the context of interstate pollution, we see that the legal arguments that these sorts of claims should be preempted at the front end really just don't work. There certainly are separate arguments about the scope of damages, the scope of conduct that could be subject to adjudication in a given state court and so on, which are the sorts of things that will arise during the course of a trial and that are actually not implicated in this initial claim of preemption. And they're the sorts of concerns that state courts that are hearing these cases are addressing, for example, when they do the analysis to determine the extent to which personal jurisdiction applies to the defendants. But they're not the sorts of claims that arise in preemption. Let me just super quickly walk through that. The Supreme Court has held that federal pollution control statutes displace federal common law for the purposes of interstate pollution. And the Supreme Court has made clear that displacement is distinct from preemption. Displacement is based on the idea that we're choosing what the source of federal law is to deal with a certain sort of question. And once Congress has occupied that space pretty much at all, then that is the way that federal law deals with that dispute. The Supreme Court has also held quite consistently that does not preempt pre-existing state law claims and does not prevent the filing of state law claims, including for things that have interstate character. So after the Supreme Court articulated the doctrine of displacement in the context of pollution control in a case called Milwaukee 2, in a subsequent case called International Paper versus Ouellette, it held quite explicitly that individuals in Vermont who were being affected by an International Paper mill that was operating in New York could sue in state court under state law, provided that they did not apply a more stringent standard to the defendant than would apply in their source state. So the fact that these kind of cases can still continue, and it's worth noting International Paper versus Ouellette, after the Supreme Court clarified that Vermont would have to apply New York law, not Vermont law, to the case, that case continued. It continued against both the air and water emissions of that facility, and ultimately, after discovery, resulted in a substantial judgment for the plaintiffs. That is the same framework that applies to the Clean Air Act, as Justice Ruth Bader Ginsburg's opinion in American Electric Power versus Connecticut makes very clear. It makes very clear that the standard for displacement and preemption are different, and that the question of preemption is a function of the preemptive effect of the Clean Air Act, which, like the Clean Water Act, has a quite robust savings clause. Indeed, it has a savings clause that's arguably more robust than the Clean Water Act. More broadly, I think we need to think about the Supreme Court's broader federalism jurisprudence. And I'm certainly open to the argument that aspects of that jurisprudence aren't great. But when we look at the Dormant Commerce Clause jurisprudence in cases like National Pork Producers, that completely rejects the idea that there is some sort of extraterritoriality limit under the Dormant Commerce Clause. We look at cases like Wayfair, which says a state can impose the obligation to collect taxes on entities that have no operations within that state. A case that, by the way, Justice Gorsuch joined that opinion, Justice Thomas, I believe, joined that opinion, Justice Alito joined that opinion. We see a court that is not as protective of horizontal federalism in these sorts of contexts as we might like. In this case, the Colorado courts determined that the defendants have activities in the state of Colorado. They have emissions in the state of Colorado. They are subject to the jurisdiction of the state of Colorado. And so for the purposes of preemption, that means that the plaintiffs get to try and make their case. Now, I'm skeptical that they can actually make it. I'm skeptical that they can actually show the degree of impacts on specific things that cost or impose costs on the county of Boulder. That's something they will have to try and do. But there's no basis for preempting that. Last thing I'll say, it's the nature of tort litigation against national companies or multinational companies that an adverse judgment in one state can affect the availability of products nationwide. We see that all the time. That is the nature of our tort system, which is fundamentally a state law-based system. The argument that in some cases there might be judgments under state law that have broader policy effects that we don't like is a really good argument for legislation. It's a really bad argument for the Supreme Court to warp or distort its traditional doctrines and discard precedent to produce something that really should be the result of the political process, not the result of litigation.
Michael, I'm going to turn it back to you because I think there were a number of different things raised in the last couple minutes. Let's take the preemption part first, and then maybe we can then talk about these extraterritorial effects and the effects of tort claims and tort litigation on consumers in turn. So, Michael, let's start with preemption if possible.
You're hurting me, Annie. I want to take it all in one bite, but it also hurts me to fight with Professor Adler, who I very much like and respect. But I'm going to give it my first run here. As you might be unsurprised to hear, I take a slightly different view of some of the authorities here. I think OLET, or however we pronounce it, I'm always going to get that wrong. We read slightly differently. I think that it actually stood for the same proposition that I was suggesting that West Virginia agrees with, which is that a state can in fact impose the emitting state's law on the emitter. I think that's not that surprising. I think where we take a different view is that OLET doesn't greenlight a state like Colorado imposing its law on emitters in Texas, West Virginia, Canada, Saudi Arabia. I think at the point at which you're talking about the law of emitter states, it falls apart pretty quickly in a context like carbon dioxide emissions, where there is sort of this global activity that, as the Supreme Court has put it, mixes well in the atmosphere and then creates this sort of uniquely universalized, globalized harm. So I think that's much different. To say that a state where emissions occur can apply that state law to a discrete emission, that actually is not that inconsistent with the sort of discrete pollution that occurred in Milwaukee 1 or Milwaukee 2, for instance, in Lake Michigan. That's, to me, quite consistent with the way the court has always viewed interstate pollution regulation. I would take a slightly different read of the savings clause in the Clean Air Act itself. I know different people have read this differently, but I think if you actually look at what the court is talking about when they talk about, or excuse me, what Congress talked about when they talked about enforcement and adoption of particular emissions standards and emissions limits, those are terms of art within the Clean Air Act, and they're specifically targeted towards the conduct within that state's own state borders. And there are other parts of the Clean Air Act that specifically talk about how to engage with emissions that are coming from outside the state's borders. Section 126 talks about when one state's being harassed by emissions from another state, there's a process by which you go through and you deal with those emissions. But that's not what Colorado is trying to do here. They're trying to, again, reach outside their own borders and regulate what is lawful conduct in the state of West Virginia or the state of Texas or the state of Louisiana and say, no, we're going to actually impose what is effectively a damages remedy and regulate out that conduct in a way that operates outside the regime of the Clean Air Act. So I guess I would chiefly object to the idea that this is a non-textualist sort of policy-based argument. I think it's both consistent with the way that the Supreme Court has viewed it in OLET, but it's also consistent with the structure of the Clean Air Act, which throughout its text contemplates lots of room for states to regulate within their borders, but doesn't contemplate the same degree of discretion outside their borders.
Michael, there was a portion of the brief, if I recall correctly, that talked about some of these state laws that directly conflict with each other. And I think that's a good jumping off point to talk about this extraterritoriality issue. I think if I recall correctly, there was something about California tried to punish something and Texas was basically immunizing the same behavior, giving some sort of refuge for downstream effects. There are some other places I think that were cited in that brief, which I apologize for not having right in front of me. But I think that's a good time to let's go ahead and transition a little bit more into the extraterritorial effects. OH, do you want to take a stab at that, or do you want Michael to continue?
I mean, I feel put upon. The professor thinks that my structural constitutional beliefs are policy arguments. I mean, look, I think what you're seeing in this I'm not a Clean Air Act expert, so I'm really going to push that to Michael. He's the person I would call if I had a Clean Air Act problem. But I think when you look at a lot of what's being said about the extraterritoriality concerns, it's like there's like a clink and a clunk in the sleight of hand to it that's mildly frustrating, which is when you have a case like Wayfair where somebody doesn't have operations in a state, but they're sending a product into the state. When you have the pork producers, right? And all of that, the governing conduct is if you're going to send pork into California, you have to put the right stickers and you have to have that pork be grown a certain way, right? If in Wayfair, if you're going to send the product, we're taxing that product. We're not taxing the company for their entire global operations when they have no operations in the state, right? And when you talk about this concept of like product liability affecting outside the state, it's true in that indirect bank shot way, where if you would put a fine or a liability, it could drive up the price of a product and remove it from the market. All of those are fundamentally off of what we're seeing here. Here, you're seeing the identification of global climate change. In the gun cases, it would have been nationwide gun violence. But let's just take global climate change. Ultimately, they're asking for things like a pot of money, green fitting their buildings. But the end result is, or other orders to abate the nuisance of global climate change, right? Well, technically, to abate the nuisance is to end the nuisance of global climate change. And what they're asking for is an order that doesn't just stop activity in their own boundaries. Like if Colorado or Boulder would like to end the use of fossil fuel in their state, I think perhaps they have a non-structural constitutional right to do that because they own in their boundaries. To the extent that they issue an order saying you need to abate global climate change by changing your behavior elsewhere, I think that's when you start to trigger something that's very different than pork producers, that's very different than these other cases, and where you start to activate. I'm not saying that there's a winning argument on either side here. I agree with the professor that some of these things are complicated, but you're implicating like a very different set of questions because you're starting to look like you're seeing one court governing an entire industry across the country under the guise of common law, right? So I think it's equally as interesting to think about whether this is an area where federal common law should have to govern because you're identifying one common nuisance across the country, right? You're not identifying the nuisance. Occasionally you see these cases like in Multnomah County where they identify one particular climatic event or a heat wave that they say is the problem. But for the most of these cases, it's just global climate change, which they would say is affecting everyone across the country. So I think that the structural questions here are real. They're not policy-based questions because they are separate from climate change. I mean, to me, it just comes down to a question of, do we have a system, whether the topic is climate change, and by the way, from my perspective to the left, climate change is everything and everything is climate change, right? So if it's climate change, then it's everything. Or whether it's guns or whether it's any other one of these topics, do we have a structural system where one state is allowed to issue injunctions that are governing conduct far afield and where you're starting to regulate the economies far afield through a courtroom with no democratic process? Or do we have a system where there is a structural limitation on the reach of states beyond their own boundaries, right? Historically, these cases have played in these joints that I think are pork producers, I think is a very different kind of case. You have these cases where you have large economic power being deployed and people might not like the effects of that. But this is much more like the case where somebody is saying, I'm going to tax you for actions that you took in Florida, even though I'm in Oregon, because I'm claiming there's an indirect effect on me across those boundaries. And I think those are just different kinds of questions that activate an entirely different core sovereignty. I mean, cases like Shelby County come down to the idea that like states have to be treated equally and you have equal sovereignty amongst the states. There's a fantastic brief by Will Consovoy that's on these topics. But I think these questions are going to be the much more interesting questions as the court takes up this case, because I think that the Clean Air Act only addresses this kind of case, whereas these questions speak to a much broader set of problems that we are seeing percolating up. And I think that they are much more serious questions than merely policy disputes.
I'm going to let Professor Adler get back into the conversation.
Yeah, I mean, I think we need to actually, focus on what the issues are in this case, right? There is no request for an injunction in this case. There is no request for imposing anything outside of the jurisdiction. The district court or the trial court in Colorado found jurisdiction against these defendants because they are present and engaged in activities within the state, and they committed alleged tortious activities within the state. In the course of that litigation, there will be the question about what activities that these companies have engaged in can or cannot be subject to liability in a Colorado court under Colorado law. Those are important questions, and we might actually agree on how those questions should be resolved in terms of what quantum of the effects of climate change can Colorado actually seek relief for. And as I've already noted, I'm somewhat skeptical that when it gets down to subdividing, what effect of climate change can be a result of these companies' actions in Colorado or that are sufficiently related to Colorado that it can address them in a Colorado courtroom, that the effort to engage in attribution for purposes of tort law may all fall apart. But what's at issue here is a claim for damages based on effects in Colorado against defendants that are active in Colorado and that, as the trial court found, have engaged in, at least for purposes of the motion to dismiss, alleged tortious conduct within the state of Colorado. So that's what's at issue here. And while some of the folks supporting this litigation or cheering on this litigation or funding this litigation may have broader ambitions, the Supreme Court is supposed to look at the legal issues that are actually in front of it. And so that's this case. And I think that's very important for us to keep in mind. Other thing I think that's really important just to keep aware is a lot of these arguments about the Clean Air Act have a really interesting posture right now because the Environmental Protection Agency has just finalized a rule saying, in effect, that the Environmental Protection Agency can't regulate greenhouse gases under the Clean Air Act. And a lot of folks suspect, I'm one of them, that rule can't be upheld without overturning Mass versus EPA, which not only would undermine the preemption arguments here, but also would result in an end to displacement under American Electric Power versus Connecticut, because displacement there is based upon Congress having reached greenhouse gases. So if the court ends up correcting its error in Massachusetts versus EPA on how the Clean Air Act should be interpreted, that requires the opposite result in American Electric Power. Last thing about the Federalist system we have to keep in mind is that the relationship of the states among each other has to be reciprocal, right? The reason why all 9 justices in International Paper versus Ouellette agreed that the Vermont plaintiffs could continue to litigate provided they didn't engage in home cooking in the way they framed their case is because just as we don't want a state extraterritorializing its regulatory preferences, we don't want a state extraterritorializing the costs of its economic activity, right? I used to live in Ohio. We sent a lot of emissions into New England and probably into Canada as well from coal-fired power plants and the like. And just as our Federalist system should prevent California from requiring every state in the country to adopt whatever California's view of the good life is these days, it should prevent a state from effectively extraterritorializing the cost of its activity, which is one of the reasons why the International Paper versus Ouellette rule makes a fundamental amount of sense, which is these things are reciprocal. If conduct in a given state could be tortious within that state, the fact that some of those harms cross state lines doesn't mean the downwind or downstream people are devoid of or deprived of a remedy. It just means their remedy has to be equal to or congruent with the remedy they could get if they were on the other side of the state line. Thus far, on the posture that this case is presented to the court, that rule is not violated, although I acknowledge that as this case goes on, the plaintiffs might certainly ask for things that would violate that sort of reciprocity. But those are kind of back end or kind of in the course of litigation sorts of questions. Those are not and have never been considered front end preemption questions, where the court to decide they are front end preemption questions would make a dramatic change in the way preemption has operated, not merely in the context of pollution, but in a wide range of other contexts as well.
I want to keep things moving. I'm going to, I saw behind the scenes, not on the main feed, Michael's face perk up there for a second about the mass versus EPA. So I want to take 1 minute or two to go down that and let you have a response to the mass versus EPA bit. I also want to talk about, Professor Adler brought up a point about the reciprocity between the states. I do want to get to that. And then also the very important piece that's the posture of this case, I think that is illustrative to many different things. So Michael, let's take a minute and go back to the mass versus EPA moment, and then we'll proceed with the rest of the conversation.
I don't get to answer the posture question. I at least want.
I'll give that to you too.
Well, I'll take that one first then. You put two lawyers in a room, they can argue about whether it's blue or red, but I think I read it differently. I think if you actually read the amended complaint, there is a focus on these global harms, and necessarily so, right? That's the nature of carbon dioxide damage, is sort of a necessarily globalized, nationalized type harm. So I do take issue with the suggestion that it's sort of a Colorado-focused, Colorado-premised case, and I think the reality is I think that's going to be something that the Supreme Court's going to have to wrestle with. I'm not going to pretend like it's 100% clear, but I would say that it sounds a little bit like what New York was trying to do in the city of New York case, but I know that Professor Adler has feelings about that decision as well. But they were doing a similar game where they were premising their supposed jurisdictional hook on activities in New York, while at the same time saying this is really about global climate change. And I think it's just too hard to play that game. And I think ultimately, I hope the Supreme Court recognizes as much. But as for Massachusetts v. EPA, I don't know that I would necessarily go as far as saying that the endangerment finding means that the EPA is taking on Massachusetts v. EPA on its own terms. I don't think they have to go that far. I think that even Massachusetts v. EPA left room for EPA to make a different determination about the way in which they wanted to exercise their authority. And I think that EPA arguably just accepted that invitation in their recent endangerment finding. I'll concede that their engagement with some of the major questions angles in particular raises some real interesting wrinkles when it comes to Massachusetts v. EPA. But I do want to disabuse our listeners of the notion that EPA can only win, or just did this as an attempt to get another a backdoor shot at reconsidering Massachusetts. I don't think they actually have to go that far. If Massachusetts were overturned, look, it's an interesting world, and honestly, sitting here today, I can't give you credible advice about how we view it in a post-Massachusetts world. I would say, though, that I find it meaningful that Milwaukee, of course, came about long before Massachusetts, and the federal common law world kind of existed long before Massachusetts. And I still have a little bit of heartburn at the notion that something about the way that the Clean Air Act is operating just erased wholesale all of those considerations that exist from that federal common law context. Again, I think that's maybe one of the principles that the Second Circuit had some trouble with, and I have some similar trouble with it as well. I hope that answers your question.
Yeah, let me digress a little bit, or maybe go back to first principles for a little bit. We've got three different questions all along the same lines, and they're about the question presented that got added about the jurisdiction of the court. So I'll go ahead and read these from the questioners. And again, a reminder, if you have a question, you can put it in the Q&A box, and I will try to get to it. The first question, and again, these are all three related, I believe. Could you discuss why the city of Boulder chose to waive their reply? The second one is, why did the court accept cert in this case and not previous climate change cases? And the third is say a little bit more about the jurisdictional issue that the court asked the parties to brief. So if anyone wants to take a bite at that first, looking for cues. Go ahead, Professor.
I think just why did they not reply at first? I think their view was anything that lowers the salience or the profile of the litigation is good for the respondents. A lot of folks think that when a cert petition is filed, that filing a reply only raises the profile of the case. So I think that's why they didn't file a reply initially. There was the court had denied certiorari in a whole bunch of these cases, seeking to raise the complete preemption. basis for removal and had denied certiorari in some other cases, Hawaii, Minnesota, and the like. So I think the theory was, don't rock the boat. I think the court's view is there are enough of these cases, and the argument that Colorado Supreme Court and the Hawaii Supreme Court, on the one hand, create a circuit split with the Second Circuit's opinion in the New York case. It's a plausible argument. I mean, I think that this relates to the last little bit about the added questions. In the Hawaii case, it's harder to argue that their Supreme Court had jurisdiction because of the way that case kind of worked its way up. The Hawaii Supreme Court dealt with it on a more pure interlocutory basis, I guess is the easiest way to simplify it. Whereas here, there's at least an argument that for purposes of Colorado law, this is not an interlocutory judgment, and so therefore a potentially clearer basis for federal jurisdiction. Although the fact that the Supreme Court added those questions back in, I think shows that there's some hesitancy there. And I would just note more broadly, I think this is a current court that doesn't like intervening in tort litigation. We've seen a lot of big judgments against a lot of companies in a lot of contexts, and the courts waved them away. Talcum powder litigation is I think one of the best examples of that, right? Billions of dollars in judgments. The court wants to have nothing to do with it. Just a term or two ago, it had taken 2 securities class action cases and then digged them both. I think the court just in general feels, on the one hand, this is clearly a big legal issue. Whether they agree with me or not on the merits, it is a big legal issue. There is a lot of litigation going on in this space, and potentially a lot of uncertainty. And that's weighing against the court's view that tort litigation is messy. There's a lot of stuff. It's hard to know, or hard to clearly grasp a clean legal issue before the litigation is over. And by the time the litigation is over, maybe it's too late. And so I just think they're reluctant to get into that space. But in this instance, I think they were convinced. Last thing I'll note, as much as I disagree with it, I think the Solicitor General's brief that was filed by the Trump administration was very strong. And it would not surprise me if that helped tip the scales into taking the case.
Yeah, OH, I know one of the big things about this, and some people always say, just wait till the whole case has been litigated, and then the Supreme Court can take up very nicely with all the edges trimmed and everything tied off. What's your response to that?
Yeah, I mean, Professor Adler and I talked about this a little bit at the National Lawyers Convention. I think one of the things that drives that perhaps drove the court to this, look, I think the USSG is one of the best lawyers in the country and a tremendous human being that I hope everyone acknowledges for how great he can be. But one of the things that I would flag is this is not tort litigation in the way that any of the ways that the professor just flagged. I agree that the court probably, especially with the questions that are coming up in this world, does not have a strong desire to weigh in to decide whether somebody's going to pay $4 billion or $8 billion. All of these other cases are cases where you're just arguing about an amount of money and whether one side gets a slightly better deal or the other side gets a slightly better deal. And the parties are very clearly interested in eventually reaching a resolution. Money will change hands and everyone will move on. This type of litigation is a tort claim, but it's very clear. I mean, we've had FedSoc webinars where people involved in the litigation writ large have identified that the ultimate goal is not $12 billion for this town or $5 billion for this or some new air conditioners for that building. It's to either get a carbon tax pressed through Congress, a backdoor carbon tax through litigation, or force the energy companies into bankruptcy so that the localities can take them over and use them as they see fit. If global climate change is the problem that these localities have identified, they're not going to be happy with a settlement and resolution for $4 billion here or $2 billion there. This is not traditional commercial litigation in that respect. This is, I'm trying to accomplish my policy goals through litigation. And the court, I think, is finally coming to perhaps grips with the idea that you can't just say, they'll resolve themselves, they'll settle themselves. Like us taking a case or not will just traditionally, as most of the advocates on this call will identify, appeals and things just, they alter the landscape for the mediation or the settlement, okay? A lot of judges I know refer to courtrooms as summary judgment rooms now, right? They're not referred to as rooms that you would ever go to trial. And I think the thing is that these cases aren't that. One side would like to fundamentally reshape an industry, fundamentally reshape the American economy, and either take over through bankruptcy or impose a carbon tax to control an entire section of the economy. And there's no making peace with that. And ultimately, you see these cases come up year after year after year. And the court, I think, is perhaps coming to grips with the idea that like there is no end to this saga until you decide whether or not these claims get to proceed and reach across the states. And so I do think that I totally agree with the professor. This court is not seemingly very excited about taking up tort cases and doing plaintiff's first business cases. But I think that this case is not that. These cases are not that. And as people have come to understand that, it's perhaps driven people to say, we need to take on these cases because they're not going to go away unless one side just agrees to be taken over in bankruptcy by the other side. And I don't mean bankruptcy like we put our talc subsidiary into bankruptcy. I mean like take over the industry through bankruptcy.
We only have a couple minutes left. I had a question come in from the audience. Could Colorado similarly sue candy manufacturers or soda companies for those who suffered damages of diabetes or other health effects that fall on society writ large, or or sales of candy or soda in that state? I mean, I think we actually have seen similar litigation that's already pending. OH, I think you've been tracking some of that.
Yeah, I mean, you have a case with the notorious trial lawyers at Morgan & Morgan doing just that. I mean, ultimately, and this gets back to questions of, this is where I think that the preemption arguments are interesting, and they're strong, perhaps they're not. But if nuisance is allowed to affect nationwide policy like this through one state courtroom, my home state of Indiana Sullivan County has 3,000 people, right? They got a courthouse. Are we going to have injunctions? And and to the professor's point, like this case does not, it says we're not trying to enjoin energy production, but in just 4 paragraphs before, it says we need an order abating the nuisance and the effects of climate change on our municipality in whatever ways, right? So like one hand, other hand. You would see this on almost anything that is identified as a nationwide problem, whether that's guns, whether that's highly processed foods, whether that's sugar, whether that's climate change. That's why I think this case is so much more interesting than just a Clean Air Act preemption climate change case.
Great. I know we're butting up right against the end of the time here. I'd like to give everybody, maybe 60 to 90 seconds for any parting thoughts, and then we'll try to wrap up from there so we get everybody out on time. Professor Adler, I'll let you start.
Sure. I'll just say, the history of environmental law going back to the 17th century is initially using litigation, nuisance and trespass in particular, to deal with the harms of economically productive activity and the fact that some communities or some individuals bear those costs and shouldn't have to bear those costs. And that history is also one of legislatures deciding that for a variety of reasons, maybe the courts are getting it wrong, or maybe litigation creates too much uncertainty or is too costly to replace or supplant that litigation with legislative action. OH mentioned gun litigation. That's exactly what happened, right? Lots of folks tried to sue gun manufacturers for the consequences and costs imposed by gun violence, trying to make the manufacturers liable for that. As a country, we made a collective policy judgment, I think a correct one, that sort of litigation doesn't make sense, is contrary to Second Amendment values, and leads to a lot of mischief. And so the legislature enacted something to remove those sorts of cases. And my view fundamentally here is this is the same sort of thing. Colorado or Boulder County has made a plausible case for purposes of motion to dismiss that they are bearing some costs as a consequence of activities that they believe contribute to climate change. And unless and until the legislatures prohibit or bar that sort of litigation, they should get their chance to try and make their case in court without regard for whether any of us on this call happen to think that it's a good case or the sort of case that we would like to see succeed. That's the way our system traditionally is operated. It's the way it should operate here.
Cool. I'll turn it to you next.
Yeah, I guess just to address that point in part, I am actually fine with the notion of using environmental litigation to some extent. I don't think West Virginia has any real problem with that either. But I think, when Professor Adler talks about the localized uh, genesis of these sorts of lawsuits, that's exactly the point. That environmental litigation has a role to play for real localized problems. I think it becomes a much different discussion when we're talking about global issues like climate change necessarily is, and we're trying to actually resolve things on a global scale or a national scale that just can't really rightfully be resolved in a local courthouse. We haven't even gotten to talk about the foreign affairs and international aspects of some of these cases as well. So I think that's really maybe the fundamental difference of opinion here is that I think from our perspective, those interests have actually been addressed by Congress and the Constitution itself in various ways. And they say that the localized concerns are one thing, but the national and international ones are another. And ultimately, I would say um, I don't want anybody under a misapprehension that we think climate change just shouldn't be addressed or it should be ignored or it isn't a real thing. I think all the states that sign these briefs think that these are real serious issues that should be appropriately addressed. But the appropriately part is the important part, that they actually should be addressed through a deliberative process that allows meaningful stakeholder contributions and meaningful involvement by all the relevant decision makers. And that's unfortunately not going to come in a state courthouse.
Rach, I think we have about 2 minutes left.
Great. Well, I would just say um, the litigation is a path to accomplishing policy goals that cannot come through Congress. They all typically come from one side in this nuisance space. It's basically, as you see less and less control by the left over different arms of the federal government, it's an effort to regulate through the courtroom. Congress passes a law to protect guns. New York passes a change to their public nuisance law to circumvent that and brings a new lawsuit. I think that's the cycle that we're going through. My only takeaway for everyone is that on page 23 of the cert petition, there's like a one-page discussion of equal sovereignty, state sovereignty, and equal jurisdiction of the states and extraterritoriality. I'm going to bet you a nickel that large swaths of the amicus briefs and the argument and the discussion at the court and the ultimate opinion will take on, at least some of the justices, these questions of equal sovereignty, extraterritoriality, structural constitution, and questions that kind of speak to nationwide injunctions, but now from a state out to the rest of the country. And so I just think everyone needs to pay attention to that. It's going to be a very different aspect than what they saw in the petition. And I think that it will be very edifying for the rest of the jurisprudence of the court to see how they treat this.
Thank you all for joining us today. Elizabeth, I'll turn it back to you to close us out.
Yeah, thank you. On behalf of the Federalist Society, I want to thank our experts for sharing their time and expertise with us today. And also I want to thank the audience for joining and participating with their wonderful questions. Just a quick note, we welcome listener feedback. You can email us at fedsocforums@fed-soc.org. Thanks again for joining us, and we are adjourned.